Hello aspirants, welcome to our Geology Concepts, and you are watching the Current Connect series, your go-to source for the current affairs and updates on the UPSC Combined Geoscientist examination. I'm your host Ritesh, and I am thrilled to embark on this journey of knowledge and exploration with you. To excel in this examination, it is crucial to stay updated with the latest happening in the world of geosciences as well as the broader field of current affairs. Our mission here is to equip you with the information you need to succeed in this examination. Whether you are a beginner or an experienced candidate, we will cover a wide range of topics to keep you informed. Each week, we will dive into the most significant events, discoveries, and developments that are relevant for the General Studies paper of the UPSC Combined Geoscientist Examination Prelims. Today, we will cover important current affairs related to Indian polity and governance section for the month of May as per your prelim syllabus. So, without any further ado, let's get started. The first topic is poor performance of 17th Lok Sabha, that is the current Lok Sabha, making it the shortest full-term Lok Sabha since the year 1952. Now let's break down the topic. The Lok Sabha, that is the lower house of the Indian Parliament, plays a crucial role in shaping our nation's laws and policies. However, the current 17th Lok Sabha has faced several challenges, leading to a decrease in its overall effectiveness and productivity. One of the primary reasons for this poor performance is legislative gridlock. What is that? The number of sitting days or the days when the Lok Sabha is in session has been significantly lower compared to the previous terms. This hampers the progress of pending bills and delays the important legislations. Furthermore, there has been a decline in the number of bills referred to parliamentary standing committees for scrutiny. These committees, that is the parliamentary standing committees, play a vital role in legislative process by thoroughly examining the bills and providing valuable inputs. The reduced number of bills referred reflects a lack of constructive debate and thorough deliberation on important issues, right? So, and then according to Article 93 of the Indian Constitution, the Lok Sabha should choose a speaker and deputy speaker as soon as possible. However, 17th Lok Sabha has not yet elected a deputy speaker, which further hampers the smooth functioning of the House. In this context, it is also important to consider the impact of the COVID-19 pandemic as well. The pandemic disrupted the normal functioning of the Lok Sabha, and it led to the cancellation of several sessions and decrease in overall attendance. This has contributed to the inadequate progress in the legislative agenda. So what does all this mean for the aspirants or students like you? It highlights the importance of understanding the functioning of our democracy and the challenges it faces. It's crucial to analyze the reasons behind the poor performance of the Lok Sabha to address these issues and improve the legislative processes. So from this particular topic, the relevancy for our examination lies in the topics like election of deputy speaker, constitutional provisions for parliamentary sittings, which is Article 85 of the Indian Constitution that deals specifically with the duration of the sessions of the parliament. According to this article, the president summons each house of the parliament to meet at least twice in a year, with a gap of not more than exceeding 6 months between the two sessions, right? This is important for our exam. And also, powers and function of deputy speaker is also relevant. So please refer to the chapter on parliament from M. Lakshmikant for the specific topics that I have mentioned right now. And now let's move on to the next topic. That is, in a significant development, the Supreme Court has held that it can directly grant divorce in cases where marriage has irretrievably broken down, bypassing the waiting period prescribed under the Hindu Marriage Act HMA of 1955. Under Section 13B of the HMA, that is the Hindu Marriage Act, couples seeking divorce through mutual consent must file two motions with a waiting period of a minimum of 6 months and maximum of 18 months between the two motions. However, the Supreme Court clarified that granting divorce on the ground of irretrievable breakdown of marriage is not an automatic right, but a discretionary power of the court. The Supreme Court's power to directly grant divorce stems from Article 142 of the Indian Constitution, which grants the court the authority to provide complete justice. Remember the word complete justice between parties when the law or statute may not provide a remedy. That means Supreme Court can act on its discretion when there is no specific law on a special issue. This power stems from the Article 142 of the Constitution. That's what this article is all about. Supreme Court has used this power during the Babri Masjid case, where it ordered the framing of a scheme for formation of a trust to construct Ram Mandir in Ayodhya. Also in Bhopal gas tragedy, the Supreme Court ordered compensation for the victims, invoking the Article 142 of the Constitution. However, powers of the Supreme Court under Article 142 has been criticized because of the ambit of power is arbitrary and ambiguous. Obviously, there is no explanation on the jurisdiction of Article 142. There is no proper explanation on what constitutes the word complete justice, and also this violates the separation of power doctrine. So that's all you need to know for this particular issue, right? The Article 142 issue. Now, the next topic is a recent Supreme Court ruling upholding the bull taming sports called Jallikattu and a traditional buffalo race known as KAMBALA. Right. So let's dive into the topic. Jallikattu is a traditional bull taming sport that has been practiced in Tamil Nadu for over a century. It involves participants attempting to retrieve prizes tied to the horns of a ferocious bull. The whole rationale behind it is to preserve the best breed of bulls which will be used for the insemination. Kambala, on the other hand, is a buffalo race celebrated in the coastal Karnataka after the paddy harvest. So recently, a constitutional bench of Supreme Court upheld that the amendments made by the Tamil Nadu, Maharashtra and Karnataka government to the Prevention of the Cruelty to Animal Act of 1960 is valid. This means that the court has allowed the continuation of these sports, that is Jallikattu, Kambala and Bullock Cart races. The court also observed that the 2017 Amendment Act and rules on Jallikattu are in line with the entry 17 of the concurrent list. As we know, we have three lists: state list, the central list, and the concurrent list. So entry 17, the Jallikattu is in line with the entry 17 of the concurrent list, which deals with the prevention of cruelty to animals. Also, it is in line with the Article 51A G of the 51A Clause G of the fundamental duty of the Indian Constitution, which promotes compassion towards living creatures. The judgment also emphasizes that Amendment Act aims to prevent cruelty to animals and addresses concerns raised before the legislation was enacted. It ensures that the animal participating in these traditional events are treated with care and respect. However, it is also important to note that Supreme Court mentioned that Jallikattu issue is debatable and that the final decision on its legality should be made by the Lok Sabha, that is the House of the People. So to sum it up, recent Supreme Court ruling has allowed the continuation of Jallikattu, that is a traditional bull taming sport in Tamil Nadu, and Kambala, a buffalo race in coastal Karnataka. The court upheld the amendments made to the Prevention of Cruelty to Animals Act, ensuring that these practices are carried out with compassion and without cruelty. So that's all you need to know about these two sports, that is Jallikattu and Kambala. Next, in this topic, we will delve into the hill-valley tension in Manipur and the demand by the Meitei community for scheduled tribe status. Let's explore the complex issue. To understand the issue, let's talk about some geographical context first. Manipur, a northeastern state of India, is divided into two distinct regions as shown in the figure. The Central Valley, comprising only 10% of the geographical area, is home to Meitei and Meitei Pangals, who make up about 64% of the state's population. So 64% of the population living in the 10% of the geographical area. And the remaining 90% of the state's land is occupied by hills, where various recognized tribes reside. And they account for approximately 34 to 35% of the state's population. The Meitei community, predominantly living in the valley, has been demanding inclusion in the state's scheduled tribe list since 2012. They argue that their exclusion from the ST category has left them vulnerable without any constitutional safeguards. Recently, a single judge of Manipur High Court passed an order directing the government to consider the demand of the Meitei community for ST status. However, this order has faced opposition from the tribal groups residing in the hill region. The opposition to the inclusion of the Metis in the scheduled tribe category is primarily driven by the concerns over the dominant population. As I said, 64% of them, they constitute the 64% of the total population. They are dominant population in the valley region. And also the political representation of the Metis community with a significant number of assembly constituencies located in the valley. There is also a fear among the hill tribes of potential job losses. It's worth noting that the Metis language is also recognized in the constitution, and certain sections of the Metis community are classified as scheduled castes or other backward classes, providing them with certain opportunities and benefits. So what's relevant for us in this context for the exam is the imposition of Article 350 in this context. So Article 350 of the Indian Constitution empowers the central government to protect states from internal disturbances and ensures the maintenance of law and order. It states that it shall be the duty of the Union to protect every state against external aggression and internal disturbances. By invoking Article 355, the central government can provide support and assistance to the state government of Manipur in dealing with the Hill Valley tensions. This may involve deploying additional security forces, initiating dialogue between conflicting parties, and implementing measures to restore peace and harmony in the region. This comes under the emergency provisions enlisted in Part 18 of the Constitution. Interesting thing to note here is that it has no fixed duration and can continue until the central government is satisfied that peace is restored in the region. However, the decision can be challenged in the court, and hence it comes under the judicial review. That's all you need to know for this particular issue. Next, we'll discuss the Supreme Court's notice seeking compliance with its judgment in the case of Anuradha Basin versus Union of India and others, which laid down guidelines regarding internet shutdowns. Let's dive into the details. The main petition was filed by Anuradha Basin, challenging the restriction imposed on the internet, media and other activities in the Kashmir region following the abrogation of its special status. The Supreme Court, in its judgment, addressed the constitutional aspects related to internet shutdowns. Freedom of speech and expressions, as well as freedom of trade and commerce through the internet, are constitutionally protected rights under Article 19, Clause 1A and Article 19, Clause 1G, respectively. However, the exercise of fundamental rights can be restricted under certain circumstances, as provided by Article 19, Clause 2 and Clause 6 of the Constitution. This restriction must adhere to the test of proportionality. Now, what is test of proportionality? The test of proportionality is a legal principle used to determine whether a government action that infringes upon an individual's fundamental right is justified or not. It assesses whether the action is necessary to achieve a legitimate aim and whether the impact on rights is proportionate to the aim it has been used for. In the Anuradha Basin case, the Supreme Court issued specific direction related to internet shutdowns. Firstly, it stated that an order suspending the internet services indefinitely is impermissible. It cannot be suspended indefinitely under the Temporary Suspension of Telecom Services Act or Rules 2017. Secondly, the court emphasized that any suspension of the internet should be for a temporary duration only, and the duration should be reasonable and necessary. Lastly, the court ruled that any order suspending the internet under the suspension rules is subject to judicial review. It is not immune. It is subject to judicial review, ensuring that it can be examined for its compliance with the principle of proportionality and constitutional right. These guidelines serve as important safeguards, ensuring that the power to restrict internet access is exercised in a reasonable and proportionate manner. So, you need to know that right to internet is a fundamental right under Article 19 of the Constitution. Okay, so that's all that you need to understand about this particular issue. Next up, we will delve into the Supreme Court's observation on the independence of the district judiciary and its importance as part of the Constitution's basic structure. Let's go into the details. The Supreme Court has held that the independence of the district judiciary is a vital component of the independent judicial system, which in turn is an integral part of the Constitution's basic structure. The district judiciary serves as the backbone of the judicial system, and its independence ensures the effective administration of justice. It is often the court that is most accessible to the litigants, and it handles a significant number of cases each day. The Supreme Court, in its observation, referred to the doctrine of inherent powers of judiciary. I repeat again, the Supreme Court observed and referred to the doctrine of inherent powers of the judiciary. What is it? According to this doctrine, the judiciary must possess the inherent powers to compel the payment of reasonable and necessary sums of money to carry out its mandated responsibilities and to administer justice. This doctrine is seen as the logical conclusion of the separation of powers, ensuring the independence of the judiciary and safeguarding its ability to perform its functions effectively. The significance of the district judiciary becomes even more evident when we consider its role during challenging times, such as amidst the pandemic. The district judiciary remained efficient and they diligently carried out its functions to ensure timely delivery of justice. It is crucial to note that these observations are in line with the concept of the basic structure doctrine. What is the basic structure doctrine? In the landmark case, that is the Keswanand Bharati judgment, the Supreme Court established the basic structure doctrine, which limits Parliament's power to make drastic amendments that may affect the core values enshrined in the Constitution, such as secularism and federalism. This judgment also affirmed the Supreme Court's authority to judicially review laws passed by the Parliament. In this context, it is also relevant to know the appointment of the district judges from the exam's point of view. Appointment, posting and promotion of district judges are made by the governor of the state in consultation with the high courts. That's the comprehensive coverage for this issue and for the relevant current affairs related to the politics sections for the month of May. Now, let's explore the governance aspect of this discussion. The National Center for Good Governance, NCGG, in India is expanding its capacity to train civil servants from various countries due to the growing demand for its programs. Now, let's dive into the details. The NCGG, that is the National Council Center for Good Governance, it is an autonomous institute under Ministry of Personnel, Public Grievance and Pensions, and was previously known as the National Institute of Administrative Research, or NIAR. It was established in 2014 with a mandate to work in the areas of public policy, governance, reforms, and capacity building of civil servants in India and other developing nations. The NCGG's training program provides valuable knowledge and skills to civil servants and enable them to effectively address the challenges of governance in their respective countries. By sharing India's experiences and the best practices, NCGG contributes to capacity building efforts in India and in our neighboring countries. The NCGG is governed by a distinguished body headed by the Cabinet Secretary of India. Okay, so this is important. It is headed by the Cabinet Secretary of India. Globally, and additionally, on an annual basis, India observes the National Good Governance Day on December 25th, highlighting the importance of good governance and its role in the nation building and development. So that's all you need to remember. You need to remember that NCGG was set up in 2014. It is governed by a distinct governing body and headed by a cabinet secretary. And also, December 25th is a National Good Governance Day. So that's all you need to remember as far as the National Center for Good Governance is concerned. Next, the Ministry of Parliamentary Affairs is organizing a 2-day national workshop on NEVA in New Delhi. So what is NEVA? NEVA is a state-of-the-art workflow system deployed on the NIC cloud, that is Meghraj. It has been specifically designed to facilitate smooth proceedings of the Parliament or the State Assembly House and ensure efficient handling of legislative business in a paperless manner. So NEVA is a device-neutral and a member-centric application. What does that mean? It empowers members with comprehensive information right at their fingertips. This includes contact details, rules of procedures, a list of businesses, notices, bills, question and answers, committee reports, and much more. Members can access all of this directly on their handheld devices or tablets. Notably, the states of Nagaland and Himachal Pradesh have already embraced the NEVA application, making their assemblies completely paperless. And NEVA is a part of the larger e-Vidhan initiative, which is a mission mode project under the Digital India program. The Ministry of Parliamentary Affairs spearheads this initiative with technical support from the Ministry of Electronics and Information Technology, that is MITI, as a centrally sponsored scheme. So e-Vidhan is a centrally sponsored scheme, and it aims to digitize and bring together all legislatures of the country onto a single platform, creating a massive data depository. So that's all you need to understand. What is NEVA, that we have already discussed, what is e-Vidhan, who implements it, and how it functions. And it is a centrally sponsored scheme. So that's all you need to understand from this particular topic. Next news is about the launch of the SAKSHAM Learning Management Information System by the Union Health Ministry. SAKSHAM LMIS, which stands for Stimulating Advanced Knowledge for Sustainable Health Management, is a dedicated and unified platform developed by the National Institute of Health and Family Welfare. It has been launched under the auspices of the Ministry of Health and Family Welfare, right? It serves as a comprehensive online training and medical education system for all health professionals across the country. It aims to ensure inclusive capacity building and primary health centers in rural and remote areas to tertiary care facilities and corporate hospitals in metropolitan cities. So it covers a wide range of healthcare facilities. It's worth noting that the name SAKSHAM has been used for other impactful programs in different ministries. So you may get question on this particular topic and you may get confused. So this includes SAKSHAM Anganwadi by Ministry of Women and Child Development, Project SAKSHAM by Indian Railways to enhance employee productivity and efficiency, and SAKSHAM Awareness Campaign by Ministry of Petroleum and Natural Gas to promote awareness about green energy. But the launch of SAKSHAM LMIS by the Ministry of Health and Family Welfare, it is taking a significant step towards empowering health professionals with modern educational tools and resources. This platform will play a crucial role in advancing medical education and improving healthcare delivery across the nation. Okay, so that's all you need to understand. What is SAKSHAM LMIS? So SAKSHAM LMIS is developed by Ministry of Health and Family Welfare, but there are other projects with the name SAKSHAM, so you have to differentiate between them. That's all you need to know from this particular topic. Now, in the next topic, Ministry of Jal Shakti has announced that over half of our India's villages have achieved ODA plus status under the Swachh Bharat Mission Gramin Phase 2 program. So the ODF plus status refers to the achievement of certain milestone beyond the ODF status in villages under Swachh Bharat Mission Gramin, which is the Gramin Phase 2. It signifies that these villages not only maintain their ODF status, open defecation free status, but also have effective solid or liquid waste management system in their vicinity. Right. So several states in India have made significant progress in attaining the ODF status, ODF plus status. Telangana, Karnataka, Tamil Nadu top performing states in this regard. And the Swachh Bharat Gramin Phase 1 was launched in 2014 with the aim of eliminating open defecation in rural areas by 2019. And the Phase 2, which is implemented from 2020 to 2024-25. Okay. So it focuses on sustaining the ODF status and includes various components such as the second phase. I'm talking about the second phase. It includes various components such as solid and liquid waste management, plastic waste management, fecal sludge management, Govardhan scheme, a scheme for managing livestock waste, information education and communication, behavioral change communication, capacity building. So that's all you need to know. ODF plus, who gives the ODF plus status or ODF status? It is a Ministry of Jal Shakti. That's all that you need to understand from this. Next up, the Ministry of Education in collaboration with World Bank organized a workshop focused on the school to work transition under the STARS program. The workshop aimed to enhance vocational education and addresses the skill gap in the 6 states covered by the STARS program. So the STARS program, or the Strengthening Teaching, Learning and Result for States program, is an initiative supported by the World Bank and implemented by the Ministry of Education. It aims to enhance the quality and governance of school education in 6 Indian states. As I said, they are Himachal Pradesh, Kerala, Madhya Pradesh, Maharashtra, Odisha and Rajasthan. The program operates through Samagra Shiksha framework and is implemented as a new centrally sponsored stream under the Department of School Education and Literacy, Ministry of Education. Right. The objective of this program is to include improving learning assessment systems, strengthening classroom instructions and remediation, facilitating school-to-work transition, and enhancing governance and decentralized management in school. The program's vision aligns with India's goal for providing education for all by strengthening public school education. The STARS program is expected to benefit approximately 250 million students aging between the age of 6 to 17, and also along with that, it will also benefit over 10 million teachers. The program consists of various components, including the contingency emergency response component, which allows for a quick response to natural disasters, infrastructural damage, or health emergency affecting learning. The Parakh component serves as the National Assessment Center, setting assessment norms for students' evaluation across school boards and monitoring. It also monitors the learning outcomes at the state and national level. And also, it is a part of the National Education Policy 2020. Right. So, this sum up the discussion of polity and governance current affairs for the month of May. Now, let's assess our learning by solving certain MCQs. The first question says, with reference to the Indian Constitution, consider the following statements. Article 1993 states that Lok Sabha shall, as soon as may be, choose 2 members to be Speaker and Deputy Speaker. It is a requirement that the candidate chosen to serve as the Deputy Speaker of the Lok Sabha come from either the main opposition party or the ruling party. The statement 3 says the Deputy Speaker has the same power as the Speaker when presiding over the sitting of the House, and no appeal lies against his ruling. Which of the above are correct? So, if you say here the statement 2 is incorrect, as there is no specific requirement in the Constitution that the candidate chosen as a Deputy Speaker of the Lok Sabha must come from either the main party or the ruling party. The choice of Deputy Speaker is independent of party affiliation. So, and the other two of the other statement 2 is incorrect, and the statement 1 and 3 are correct. So, option C will be the right answer. Next question, any bans, restrictions or stipulations included in regular legislation cannot be applied to the constitutional powers granted under Article 142 of the Indian Constitution. Which one of the following could it imply? There is no legal remedy against the decision made by the Indian Election Commission while doing its duty. The legislation passed by the Parliament does not impose any restriction on the Supreme Court of India's ability to exercise its authority. President of India may declare a financial emergency without the Cabinet's approval in the event that the nation is experiencing a severe financial crisis. State legislatures are prohibited from passing some legislation without the union legislature's approval. As we just discussed, Article 142 is related to Supreme Court's power. So, option B is the correct answer. So, when it is stated that regular legislation cannot be applied to the constitutional powers granted under Article 142, it implies that the legislation passed by the Parliament does not impose any restriction on the Supreme Court's ability to exercise its authority, right? Article 142 also grants the Supreme Court wide-ranging powers to do complete justice and to pass any order necessary for the enforcement of the fundamental rights. This means that the Supreme Court's exercise of its authority under Article 142 is not limited or restricted by regular legislations passed by the Parliament. Even if there is a legislation, Supreme Court can still act on its own discretion. The next question is, what is the significance of Article 355 of the Indian Constitution? It empowers President to impose President's rule in a state. It provides appointment and dismissal of governor of a state, mandates Union government to protect states against external aggression and internal disturbances, and special, the other statement says, grants special status to certain states with unique cultural and historical characteristics. As we all discussed just now in the Manipur class context, Article 355 allows the Union government to protect states against external aggression and internal disturbances by proclaiming emergency. And the last question, which ministry has launched the SAKSHAM Learning Management Information System? It is the Ministry of Health and Family Welfare, right? So that's all for today. Join us every week as we uncover the latest developments, provide insightful analysis, and equip you with the tools you need to excel in your geoscientist journey. Remember, the key to success lies in staying informed and staying ahead. Thank you for tuning in to Geology Concepts. Until next time, keep exploring, keep learning, and keep pulsing with knowledge. Thank you.